Red wine, one please. Okay.
Oh, beverage. Not alcohol, please.
Okay. Stir it up.
Okay. So, orange is good.
Okay.
Good afternoon. I am NAJIHAH, the one that booked for the consultation. Take a seat. So basically, recently I was involved in a car accident. From what I saw, I believe that the drivers were intoxicated. I suffered injuries and had to pay my medical fees. So I came here to know what action I can take actually.
So before we go any further, do you have any evidence to support your claim that the drivers were intoxicated, like CCTV footage from the bar or maybe dash cam camera?
I actually do have some footage, like CCTV footage from the club and CCTV footage from the road. And the other one is the dash cam from one of the drivers.
Okay, that's very helpful. Evidence like that is very crucial for cases involving intoxication.
Alright, first let me explain the legal position of intoxication in Malaysia. First of all, under our Malaysian law, intoxication refers to a condition where a person's mental capacity is impaired due to alcohol or drugs. So in your case, it must be alcohol, right? Because they were drunk. Now, the relevant provisions are Section 85 and Section 86 of the Penal Code. So because it's a penal code, it is considered as a criminal liability. Now, as a general rule, intoxication is not a defense. However, the law recognizes it in a certain exceptions, and intoxication can also be taken into account when we determine intention or knowledge. The court will first look at the person's conduct before, during, and after the incident to assess whether intoxication affect their mental state or not. Is that clear?
Yes.
Apart from intoxication, I think this accident can be classified as negligence as well.
What is negligence?
Okay, negligence is a civil wrong, also known as tort. In simple terms, negligence occurs when someone fails to take reasonable care that failure causes harm to another person. There are 4 elements we need to establish. First, duty of care. Drivers owe a duty to other road users to drive safely. This principle comes from Donahue versus Stevenson, which introduced the neighborhood principle. Second, breach of duty. Driving while being intoxicated is a clear breach of that duty. And the third is causation. The breach must directly cause the accident. And the last one is damage, which we can see from here is you suffered the injuries and financial loss.
Ms. Diha, can you show us the proof that you suffer from financial loss?
So here I have the medical bills and receipts from the hospital, and also the recording from the dashcam and CCTV footage that I got from the road and club.
Flashback. Flashback.
So based on the footage and the receipt and bills from the hospital, this clearly proves the damages lah, which strengthen your negligence claim.
Honestly, I'm scared to bring this case to the court. People who are intoxicated often seem to get away with it, even when they were obviously negligent.
I understand your concern, but NAJIHAH, under Section 86 of the Penal Code, intoxication may be taken into account when determining intention or knowledge for a criminal offence. But the highlight is it may be taken into account for criminal offence. However, it does not excuse civil liability. So even if the drivers manage to avoid their criminal punishment, they can still be held liable in negligence claim. So this does not mean that they automatically escape their responsibility.
I think there's something wrong here. Something wrong?
I think driver 2 become intoxicated because driver 1 spiked his drink. What?
In the case of Abdul Aziz bin Muhammad Sharif against public prosecutor, it has stated in what kind of situation the defense of intoxication can be raised. The Federal Court decided to prove that when someone was intoxicated, the defense must provide enough evidence. This is because being intoxicated is not enough. This evidence must show that because of intoxication, the accused could not form the necessary intention or knowledge to commit the crime, or the accused was insane temporarily or otherwise at the time of committing the crime.
So, what will happen if the defense of intoxication is successfully proven?
In Section 86, Subsection 1, if the accused successfully proved intoxication under Section 85, Subsection 2, the court will decide based on two possible situations. Firstly, in Section 85, Subsection 2, Paragraph A, if the intoxication was not self-induced, then the accused must be acquitted. Secondly, in Section 85, Subsection 2, Paragraph B, if the intoxication was self-induced, then the court will treat the accused as was insane due to intoxication. In this situation, driver B may attempt to rely on the defense of intoxication under Section 85 and 86 of the Penal Code on the ground that his intoxication was not self-induced, as driver A had secretly placed drugs into driver B's drink without his knowledge. On the facts, driver B did not voluntarily consume alcohol or drugs, and therefore the intoxication falls within Section 85, Subsection 2, Paragraph A. However, the defense of intoxication does not automatically succeed merely because the intoxication was not self-induced. As explained by the Federal Court in Abdul Aziz bin Muhammad Sharif against public prosecutor, the defense must prove that the intoxication was strong enough that the accused could not form the intention or know what they were doing. In this situation, despite being intoxicated, driver B was able to engage in a series of conscious acts, including getting into the car, starting the engine, and participating in a street race on a public road. These actions indicate that driver B retained awareness, control, and the ability to make decisions. Accordingly, under Section 86, Subsection 2 of the Penal Code, the intoxication may be taken into account, but it does not negate intention if the accused was still capable of forming it. This approach is consistent with the principle in the case of R against Kingston, where the House of Lords held that involuntary intoxication does not excuse criminal liability if the accused still possessed the necessary mens rea. In that case, although the accused was drugged without his knowledge, he was still found guilty because he formed the criminal intention despite the intoxication, similarly with the present situation.
To conclude, although driver B's intoxication was not self-induced, the defense of intoxication is likely to fail because his conduct demonstrates that he was still capable of forming intention and understanding the nature and consequences of his action. Additionally, even though driver B did not voluntarily take alcohol or drugs, by agreeing to drive with driver A while intoxicated and participating in street racing, he failed to exercise reasonable care, which is behaving as what a normal driver would do on the road. Thus, both driver B and driver A are negligent.